1.1 Capacity Building of Urban Local Bodies ULBS. Why in the news? Recently, the Capacity Building Commission, CBC, in collaboration with MOHUA organised a national workshop on capacity building of ULBs to foster a unified approach to capacity building ULBs across India. More on news. The workshop marked the launch of 3 key initiatives, i.e., Annual Capacity Building Plan, ACBP, to enhance the capabilities of MOHUA. ACBP for 6 pilot ULBs, i.e. Ahmedabad, Bhubaneswar, Mysuru, Rajkot, Nagpur, and Pune. Comprehensive toolkit for preparing capacity building plans for ULBs for providing valuable resources to facilitate the growth and development of ULBs. 5 www.visioneers.nwa.visioneers.in Copyright symbol Vision IAS. About urban local bodies. ULBs are small local bodies that administer or govern a city or a town of a specified population. Urban governance, local government, is part of the state list, entry number 5, under the Constitution. Thus, the administrative framework and regulation of ULBs varies across states. Constitution, 74th Amendment, Act, 1992, formally recognized urban local governments as the third tier of government. The Act provided for the establishment of 3 types of ULBs, Nagar Panchayats for a transitional area, municipal councils for a smaller urban area, and municipal corporations for a larger urban area. It empowered state governments to devolve certain functions, authority, and power to collect revenue from these bodies, and made periodic elections for them compulsory. Functions of ULBs include urban planning including town planning, regulation of land use and construction of buildings, roads and bridges, urban poverty alleviation, etc. Measures taken for capacity building of ULBs. Capacity Building Scheme for Urban Local Bodies. CBOLBIT aims to strengthen urban local governance through capacity building for better governance and financial management, as articulated in the 11th Five-Year Plan. World Bank Assisted Capacity Building for Urban Development, CBUD, project. Its objective is to build the capacity of select ULBs, which are centers of economic growth, improve their skills for better urban management, and reduce urban poverty. National Urban Digital Mission, launched in 2021 by MOHUA, it focuses on citizen-centric digital revolution in ULBs in India. It aims to create a shared digital infrastructure working across 3 pillars of people, processes, and platform to provide a framework for digital governance in the country. National Institute of Urban Affairs, NIUA, has been appointed to anchor this mission. Established in 1976, NIUA is a premier institute for research, training and information dissemination in urban development and management. Jawaharlal Nehru National Urban Renewal Mission, JNURM, focuses on efficiency in urban infrastructure and service delivery mechanisms, community participation, and accountability of ULBs at parastatal agencies towards citizens. Municipal bonds, these are financial instruments that municipal corporations and other associated bodies in India issue to raise funds. Challenges associated with capacity building of urban local bodies. Lack of skills. The personnel engaged in managing urban affairs and municipal services lack specific skills, especially in areas like socio-economic planning, sustainable urban planning, financial management, and e-governance. Training curricula. Capacity gaps in municipal employees are augmented by capacity building deficits in the training institutions. Training curricula are program-centric or event-based, limiting their utility and further hampering the development of specific skills. Also, states' training institutes focus more on general and rural administration rather than on urban governance. Lack of awareness and participation. The disconnect between citizens and ULBs hampers effective communication. This cuts the feedback channel from the citizens, which could act as a key motivator for capacity building. Partial devolution. The 73rd and 74th Amendment Act enlists the function of local governance bodies. However, in practice, there is a lack of devolution of financial authority, resulting in local authorities having greater responsibilities without financial means to fulfill it. 6 www.visioneers.nwa.visioneers. For instance, poor finances of Bihar's ULBs are due to delays in the release of grants, inadequate devolution of funds, and delays in the revision of tax rates and assessments of land holdings. Way forward. Training. Quality training material offering a mix of classroom-based training and on-field training ought to be designed. Engaging private, academic, and non-governmental training and research organizations can further bridge the shortage of capacity building institutions. Professionalism. Developing a cadre system and provide specific training to create a strong and efficient workforce in municipal departments, e.g. engineering disciplines. Also, lateral hiring of professionals with special skills can be explored into the municipal cadre, especially the larger ULBs, for fostering greater municipal professionalism. Awareness generation. Steps should be taken to mobilize citizens, ensure active participation, and generate awareness among the public by organizing campaigns, engaging academic institutions, NGOs, etc. Fiscal decentralization. The concept of financial decentralization is a necessary aspect of effective functioning of local governance. The focus should be on providing autonomy in matters of expenditures along with resource mobilization as far as possible. This will enhance local institutions' ability to allocate funds for training and carry out developmental tasks effectively. Convergence. Institutionalizing structures of local bodies to enhance coordination among local governance bodies and bring synergy. This will indirectly increase the institutional as well as human resource capacity of the ULBs. 1.2 Criminalization of politics. Why in the news? Recently released a report titled Analysis of Sitting MPs from Lok Sabha and Rajya Sabha of India 2023 was released. More about news. It was released by the Association for Democratic Reforms, ADR, and National Election Watch. Key findings: sitting MPs with criminal cases. 40% of sitting MPs have declared criminal cases against themselves. Sitting MPs with serious criminal cases. 25% of sitting MPs have declared serious criminal cases including cases related to murder, attempt to murder, etc. State with highest percentage of sitting MPs with criminal cases. Highest percentage of sitting MPs with criminal cases in state nuts: Lakshadweep, Kerala, Bihar, Maharashtra. ADR was established in 1999 by a group of professors from the Indian Institute of Management, IIM, Ahmedabad. Its goal is to improve governance and strengthen democracy by continuous work in the area of electoral and political reforms. 7 www. Impact of criminalization of politics. Institutionalized corruption and trust erosion. Corruption thrives when the rule of law is disregarded and paired with the criminality of politics. India ranked 85th out of 180 countries, according to the 2022 Corruption Perceptions Index reported by Transparency International. Also, when politicians with criminal backgrounds hold public office, it can erode public trust in the political system. Criminalization of political parties. This is because the criminal elements can gain control of political parties and using them for their benefit. Inter-party democracy also gets adversely impacted. Affects working of investigation and prosecution agencies. Nexus between criminal politician has the tendency to influence the working of agencies. The Supreme Court in 2017 termed Central Bureau of Investigation as a caged parrot and its master's voice. Decline in conviction rate. As per SC Amicus Curiae Report, 2022, 5,097 cases are pending against lawmakers across the country. Affect conducting of free and fair elections. Due to the use of money and muscle power in elections by criminals, the elections are not conducted in a free and a fair manner. The Center for Media Studies reported that around $8 billion was spent during 2019 Lok Sabha general elections. Measures to check criminalization of politics. Legislative measures. Section 8(3) of the Representation of People Act, 1951 says any lawmaker sentenced to at least 2 years in jail remains disqualified for 6 years upon their release. Such a disqualification is enabled by Article 102(1) of the Constitution of India, which says a lawmaker can be disqualified under any law enacted by the Parliament. Similar provision exists for the states under Article 191(1). Judicial pronouncements. Union of India versus Association for Democratic Reforms, 2002 SC stated that electors have a fundamental right to know the antecedents of candidates. It states right to be informed as a right flowing from freedom of speech and expression. People's Union for Civil Liberties, PUCL, the Union of India, 2004 SC declared Section 33B of Representation of Peoples Act 1951 as unconstitutional and void. Various Commission of Committees Electoral Reforms, NN Vora Committee Report, 1993, on criminalization of politics stated that the nexus between the criminal gangs, police, bureaucracy, and politicians has come out clearly in various parts of the country. Other commissions, National Commission to Review the Working of the Constitution, 2001, Second Administrative Reforms Commission, 2008, etc. 8 www.visioneers. The section allowed candidates to furnish information only under the Act. Lily Thomas v. Union of India, 2013 SC ruled that Section 8(4) of the Representation of People Act, 1951, as unconstitutional. Section 8(4) of the RP Act earlier allowed convicted MPs, MLAs and MLCs to continue in their posts, provided they appealed against their conviction and sentence in higher courts within 3 months of the date of judgment by the trial court. Public Interest Foundation versus Union of India, 2018 SC ordered political parties to publish the criminal records of their candidates on their websites, social media handles, and newspapers. Rambabu Singh Thakur v. Sunil Arora, 2020 SC reiterated the court's 2018 directions and directed the Election Commission to report to the Supreme Court any non-compliance by political parties. Way forward. Lifetime ban for convicts from polls. Election Commission of India had mentioned it in the electoral reforms proposals published by it in 2004 and 2016. Hybrid electoral system, as suggested by 170th Law Commission report on the hybrid system, i.e., 75% through first past the post (FPTP) and 25% through proportional system. As per experts, FPTP encourages candidates to spend humongous amount in every election. Punishment for filing of false affidavits. The Law Commission in its 244th report titled Electoral Disqualification suggested punishment should be enhanced to a minimum 2 years imprisonment, and such an offence must also be made a ground for disqualification. Internal democracy for political parties. The National Commission to Review the Working of the Constitution, NCRWC, report suggested a dedicated legislation for inter-party democracy. Amending the Representation of the People Act, 1950, to debar the persons from contesting elections against whom heinous nature crimes are pending. Other reforms, right to recall, state funding of elections, fast-tracking judicial process, etc. for improving the election ecosystem of India. Related News Association for Democratic Reforms, ADR, and National Election Watch also released report analysis of sitting MPs, MLAs, with declared cases related to hate speech. Key highlights. A total of 107 current MPs, 33, and MLAs, 74, have declared cases related to hate speech. About hate speech, the Law Commission report number 267 of March 2017 on hate speech states that hate speech has not been defined in any law in India. However, legal provisions in certain legislations, like Section 153A, 153B, 295A of IPC, prohibit select forms of speech as an exception to freedom of speech. 1.3. Parliamentary privileges of lawmakers. Why in the news? Recently, the Supreme Court set up a 7-judge bench headed by the Chief Justice of India for reconsideration of its 1998 5-judge Constitution Bench judgment in the P.V. Narasimha RAO case. More on the news. The 1998 judgment of the P.V. Narasimha RAO versus State case came in the backdrop of the 1993 JMM Jharkhand Mukti Morcha bribery case. As per the judgment, legal immunity granted to legislators under Articles 105(2) and 194(2) of the Constitution protects them against criminal prosecution on bribery charges for any speech or vote in Parliament. OSC has now decided to reconsider this precedent. About parliamentary privileges. Parliamentary privileges are legal immunity enjoyed by members of legislatures, in which legislators are granted protection against civil or criminal liability for certain actions done or statements made in the course of their legislative duties. 9 www.visioneers.nw. So far, neither Parliament nor any state legislature has enacted any legislation that defines the powers, privileges, and immunities of the Houses, or that of its members and committees. It should be noted here that the Parliament, till now, has not made any special law to exhaustively codify all the privileges. They are based on 5 sources, namely, constitutional provisions, various laws made by Parliament, rules of both the Houses, parliamentary conventions, and judicial interpretations. Parliament is the sole authority to ascertain if there has been a breach or contempt of the House. No court is entrusted with this power. A member of the House can raise a question involving a breach of privilege with the consent of the chairman or speaker. What are the provisions that grant legislators immunity from prosecution? Article 105 deals with the powers and privileges of both Houses of Parliament and its members and committees. Similarly, Article 194 outlines the corresponding powers, privileges, and immunities of state legislatures and their members and committees. Right to prohibit publication of proceedings. Article 105(2) stipulates that no person shall be liable in respect of the publication by or under the authority of either House of Parliament of any report, paper, votes, or proceedings. O. A similar provision exists for members of the legislature of a state under Article 194(2). Freedom of speech in Parliament. Freedom of speech available to the members on the floor of the House is different from that available to the citizens under Article 19(2). O. Article 105(2) states that no member is liable to any proceedings in any court for anything said or any vote given by him in Parliament or its committees. This freedom is subject to the provisions of the Constitution and to the rules and procedures of the Parliament, as stated under Article 118 of the Constitution. O. However, Article 121 restricts members from discussing the conduct of judges of the Supreme Court and High Court. Freedom from arrest. Code of Civil Procedure, 1908 provides that members can enjoy freedom from arrest in any civil case 40 days before and after the adjournment of the House and also when the House is in session. O. However, this privilege is limited to civil cases. An MP doesn't enjoy any immunity against action in a criminal case during the session or otherwise. Breach of 10 www.vision 10 www. Breach of privilege. If an individual or authority disregards or undermines a parliamentary privilege of a member or the House, it is called a breach of privilege. Contempt of the House. Breach of privilege is different from contempt of the House. It defined as any act or omission which O obstructs or impedes either House of Parliament in the performance of its functions, or O which obstructs or impedes any member or officer of such House in the discharge of his duty, or O which has a tendency directly or indirectly to produce such results. Punishment for a breach of privilege or contempt of the House. The person found guilty of breach of privileges or contempt can be reprimanded, warned or sent to prison. The period for which the House can commit an offender to custody or prison for contempt is limited to the duration of the session of the House. In case its member is found guilty, the MP can be suspended from the House or face expulsion. 10 www. Privileges based on rules of procedure and precedents. Parliament reserves the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member on a criminal charge or for a criminal offence. Right to exclude strangers. Members of the House have the power and right to exclude strangers who are not members of the House from the proceedings. This right is essential for securing free and fair discussion in the House. Also, as per the provisions of Article 122, the validity of any proceeding of Parliament can't be inquired into by a court on the grounds of alleged irregularity of procedure. Need for reform in parliamentary privileges. Applicability. The scope and limitations of parliamentary privilege are yet to be ascertained. In some instances, privileges shield lawmakers from prosecution, as civil cases cannot be initiated when the House is in session. Misuse. There have been instances of misuse of powers and rights by the members of the Parliament and Legislative Assembly resulting in violation of fundamental rights of citizens. Lack of oversight. Absence of a clear mechanism to prevent members of the House from using privileges for personal or official gains interest. Lack of procedure. Parliament has yet to lay down a set of procedures to deal with instances of breach of privilege and is solely guided by exigences. O, for example, lack of clarity on whether hearing must be given to the accused or whether he or she must be given a right of legal representation, etc. Against natural justice. Breach of privilege laws allows politicians to judge their own cases. It leads to a conflict of interest, violates the principle of separation of power under Article 50, and goes against the tenets of a fair trial. Violates constitutionalism. The absence of codified privileges gives unlimited power to the House to decide when and how a breach of privilege occurs. Way forward. Providing immunity to parliamentarians is essential. However, urgent steps are required to ensure constitutionalism, such as codifying privileges, establishing standard operating procedures in case of breach of privilege, etc. Also, Parliament can establish clear boundaries by enacting specific legislation to monitor the misuse of parliamentary privileges by its members. 1.4. Interstate water dispute. Why in the news? Recently, the Union Cabinet approved the terms of reference to Krishna Water Disputes Tribunal II, KWDTII, under the Interstate River Water Disputes, ISRWD, Act, 1956. More on news. KWDTII will distribute the Krishna water, allocated to undivided Andhra Pradesh, between Telangana and Andhra Pradesh. O Krishna is an east-flowing river that originates at Mahabaleshwar in Maharashtra and merges with the Bay of Bengal, flowing through Maharashtra, Karnataka, Telangana, and Andhra Pradesh. Also, the Supreme Court criticised the Punjab government for its slow progress in constructing the Sutlej-Yamuna link (SYL) canal and asked the centre to conduct a survey of the land designated for the canal to assess the work status. About SYL Canal and the associated issue, SYL is a 214 km long canal for sharing waters of Ravi and Beas rivers between Haryana and Punjab, of which 122 km was to be in Punjab and 92 km in Haryana. O, it was planned in 1966 after Haryana was carved out of Punjab. Haryana completed its stretch of SYL Canal in 1980, while Punjab kept citing riparian principles and non-availability of its water. O, riparian principle states that owner of land adjacent to a water body has the right to use water. Punjab argues that many areas in state may go dry after 2029 due to overexploitation of groundwater. Haryana argues that its southern parts of state are facing water problem due to depleted groundwater. It claims that it has been denied its rightful share in water. 11 www.visioneers.nwa. In 1969, Krishna Water Disputes Tribunal I, KWDT, was set up under the ISRWD Act, 1956. It divided 2060 TMC, 1,000 million cubic feet, of Krishna water at 75% dependability. 75% dependability of a catchment implies that 2060 TMC of water can be reliably extracted from a catchment area 75% of the time, considering the natural variability in water availability due to factors such as precipitation, evaporation, and infiltration. KWDTII, instituted in 2004, made allocations of Krishna water at 65% dependability and for surplus flows. In 2014, after the creation of Telangana as a separate state, Andhra Pradesh asked to include Telangana as a separate party at KWDT and that the allocation of Krishna waters be reworked among 4 states, instead of 3. However, Maharashtra and Karnataka are now arguing that Telangana was created following bifurcation of Andhra Pradesh. Therefore, the allocation of water should be from Andhra Pradesh's share, which was approved by the tribunal. Factors responsible for interstate water dispute. Asymmetrical access to river water. When a river flows across a boundary between the states, the upstream state is usually at an advantage. creating an asymmetry between upstream and downstream states. Rising water demand. The total water demand in India is projected to increase by 22% and 32% in 2025 and 2050 respectively. The rising demand has put stress on limited water reserves, further aggravating the interstate water dispute. Lack of clarity on water usage rights. Under Schedule 7 of the Indian Constitution, the power to use water for storage, electricity, irrigation, etc. is mentioned under the state list and interstate water under the union list. However, these powers are interconnected and usage by one state affects usage by other states, thus creating ambiguity on water usage rights. Lack of an integrated approach. Water governance architecture in India is based on a fragmented piecemeal approach. It relies on numerical measures such as arithmetic hydrology, surplus, deficit, etc., ignoring the social, ecological, and cultural processes associated with water. 12 www.vision. Other issues. OMSPs of rice and wheat led to a manifold increase in water demand, thereby resulting in interstate water conflicts, e.g. Krishna, Cauvery, Teesta basins, or SYL between Punjab and Haryana. Boundaries of states in India have continued to alter, based on cultural and political factors. Mechanism to deal with interstate water dispute. Under 7th Schedule of Constitution, Entry 17 of State List reads water, that is to say water supplies, irrigation and canals, drainage and embankments, water storage, and water power subject to the provisions of Entry 56 of List I, a Union List. Entry 56 of List I provide that regulation and development of interstate rivers and river valleys to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest. Article 262, it says that Parliament by law may provide for the adjudication of any dispute or complaint with respect to the use, distribution, or control over the waters of, or in, any interstate river or river valley. In the exercise of the power conferred by Article 262 of the Constitution, Parliament has enacted 2 laws. Interstate Water Disputes, ISWD, Act, 1956, under it. A state government which has a water dispute with another state government may request the central government to refer the dispute to a tribunal for adjudication. River Boards Act, 1956. It was made for the setting up of river boards by the central government for the regulation and development of interstate rivers and river valleys. National Water Policy 2012. It seeks to address issues such as scarcity of water, inequities in its distribution, and the lack of a unified perspective in planning, management, and use of water resources. Challenges associated with resolving interstate water dispute. Delayed resolution. There are prolonged proceedings and delays in the disposal of river water disputes. For example, it took 11 years for the Godavari Water Dispute Tribunal to give its decision. Ambiguity. Article 262 deters the Supreme Court from adjudicating interstate river water disputes. However, Article 136 empowers the SC to hear appeals against the tribunal's orders, further causing ambiguity in the implementation of tribunal orders. Politicization of disputes. Some political parties are using interstate water disputes as avenues for pursuing political goals. Lack of multidisciplinary approach. Tribunals in India primarily consist of members from the judiciary, thus lack inputs from specialists such as ecologists, hampering the quality of orders. Way forward. Enabling cooperation. Fundamental strategic shift away from the current reliance on conflict resolution is required. Also, there is a need for deeper integration of states in deliberative processes and strengthening cooperative federalism. Basin approach. Focus on ecological restoration, conservation of river ecosystem, balancing of water supply and demand for human use, and regional approach for effective management of river water. Multidisciplinary approach. Institutional structure of Water Management Board should include experts from multiple disciplines such as environmentalists, geographers, etc. This will enhance the efficacy of water boards in providing ecological and environmentally friendly solutions. Water policy. To resolve water disputes on reasonable and equitable lines, certain parameters must be made part of the water policy. These parameters include the extent of the river basin drainage area in each state, contribution of water to the river basin by each state, climate and dependent population in the river basin, extent of arid and semi-arid areas in each state, etc. 13 www.visioneers.nwa.vision 1.5 Role of technology in public services delivery. Why in the news? The Controller and Auditor General, CAG, of India has emphasized on the need for increased use of IT systems and technology in service delivery to the citizens. Technology and linkage with public service delivery. Digital government services, also called e-government, are defined as service delivery within government, as well as between government and the public, using information and communication technologies. Traditionally, government services have been delivered in person by individual departments in different locations, and often using paper forms. With digital services, government can deliver information and services to citizens anytime, anywhere, and on any platform or device. Significance of technology in services delivery. Saves time and money for the citizens, as they need not travel to different government offices and stand in queues to get their work done. E-Hastiksha service facilitates instant e-signing of documents online by citizens in a legally acceptable form without having to visit government offices. Increases the efficiency of government departments, as the digital records can be shared easily and maintained for later references. Vehicles data from different state registers are collected and processed in Vahan platform of the Ministry of Road Transport and Highways. Eliminates the ghost beneficiaries and leakages to a larger extent, as the digital records can be updated dynamically and the leakages can be traced back easily. The linking the Aadhaar cards to the respective job cards of MGREGA, lakhs of ghost beneficiaries were identified and removed, increases the accountability and reduces corruption, as the origin or initiator of a particular transaction can be traced back to the system from where it began. The detailed information available to the citizens in the platforms enables them to understand rules and regulations better and even raise complaints on erring officers. The combination of data harnessed from various sources can be mined to design better public policies. The linking of the PAN card and Aadhaar card helps the Exchequer to collect data on persons earning above a threshold income for reducing black money and increasing the tax collection. Technological challenges in service delivery. Digital divide among the people, where a majority of them are yet to get accustomed to digital world and its applications. 14 Lack of skilled workforce within the government, which makes it difficult for them to adapt technology at a major scale. Cybersecurity threat is a major concern as these services are also to handle important data of government and public. Lack of sufficient digital infrastructure in the government establishments across the country. Lack of interoperability in most services makes them work in isolation rather than as a collective network. Way forward. Enhancing the digital literacy among the population and highlighting its advantage in the society. Creating a skilled workforce through various skilling programs in order to meet the demand. Legal framework to enhance the data protection within the country. Enhancing the cybersecurity infrastructure in the country. Improving the digital infrastructure and enhancing the interoperability of the services to widen the scope of the services. 1.6 Consumer protection in India. Why in the news? Recent finding suggests that the pendency in the consumer commissions has shown a declining trend from 5.55 lakhs in December 2022 to 5.45 lakhs in September 2023. Who is a consumer? Under the Consumer Protection Act, CPA, 2019, a consumer is a person who buys any goods or avails services for a consideration, which has been paid or promised, or partly paid and partly promised, or under any scheme of deferred payment. It applies to both offline and online transactions through electronic means, or by teleshopping, or direct selling, or multi-level marketing. However, any person who obtains goods or avails services for resale or commercial purposes is not treated as a consumer and is outside the scope of CPA 2019. Need for consumer protection in India. Informed choice. There has been an increase in the supply of duplicate or defective products in the market. CPA, through its compliance mechanisms and rules, encourages information dissemination about the products. Checking malpractices. Prevent and combat unfair trade practices such as black marketing and hoarding, and keep a check on practices that manipulate market prices. 15 www. For instance, some drug manufacturers charge high premiums on essential medicines, negatively affecting the consumer. Also, some pharmaceutical companies misuse their patent rights to exploit consumers. Misleading advertising. Many businesses purposefully deceive consumers by presenting deceptive or false advertisements, giving consumers an incorrect or partial understanding of a product or service, thus violating the consumer's right to know about what they are buying. Grievance redressal. To provide effective redressal mechanisms for consumers and address complaints in cases such as the sale of adulterated products, etc., and simultaneously hold the businesses accountable. Economic growth and competitiveness. Consumer protection contributes to dynamic and effective markets for businesses to grow. The resultant consumer demand in turn drives innovation and economic development, as businesses are required to maintain fair prices and good quality of their products and services. Measures taken for consumer protection in India. Consumer Protection Act, CPA, 2019. It provides for the Central Consumer Protection Authority, CCPA, to regulate matters relating to violation of the rights of consumers, unfair trade practices, etc. Consumer Protection, Jurisdiction of District Commission, State Commission and National Commission Rules, 2021, to provide simple, speedy, and inexpensive redressal of consumer disputes. CPA 2019 envisages three-tier quasi-judicial machinery at national, state and district levels. ConfirNet project. It stands for computerization and computer networking of consumer fora in the country. It was implemented in the backdrop of CPA, 1986. It aims to improve operational efficiency, coordination, accessibility, and speed in judicial administration, and to set information communication technology, ICT, infrastructure at consumer redressal commissions all over India. Integrated Grievance Address Mechanism, Ingram Portal. It was developed under the aegis of the Department of Consumer Affairs to create awareness, advise, and redress consumer grievances, and act as a central registry for lodging consumer grievances. eDarkle Portal. It provides a hassle-free, speedy and inexpensive facility to consumers around the country to conveniently approach the relevant consumer forum, dispensing the need to travel and be physically present. Certification markers. To protect and sensitize regarding quality standards. Different certification marks in India. Certification marks on a commercial product are usually called a mark of validity, or an assurance of the fact that the manufacturer has tested the product and has ensured that it meets the given quality standard. Bureau of Indian Standards, BIS, which comes under the aegis of the International Organization for Standardization, ISO standards, govern all industrial standardization and industrial product certifications in India. 16 www.visioneers.nwa.visioneers.in Copyright symbol Vision IAS. Pendency in cases. Despite the decreasing trend, the absolute number of pending cases at both state and national levels is huge. This results in long waiting periods and delays in dispute resolution. Vacancies in institutions. There is a lack of infrastructure and manpower in consumer forums, example, Pune, Delhi, etc., leading to inefficiency in addressing consumer complaints. Issue of clarity vis-à-vis roles and powers. There is a lack of clarity regarding Central Consumer Protection Authority, CCPA, roles related to investigations and inquiries and search and seizure function. Also, the scope of CCPA powers in matters of investigation leading to product recall or penalization of manufacturers is unclear. Rights versus duties. The realization of consumer responsibility towards ensuring the protection of their own interest along with the development of conscious consumerism is the essence of consumer protection. However, the CPA does not lay down consumer duties or responsibilities exclusively. Way forward. Advertisements. Governments should collaborate with manufacturers, distributors, and consumer organizations to develop advertising codes and standards for regulating information provided in advertisements. Safety and quality. National standards and regulations for product safety and quality should be reviewed regularly to ensure conformity with international standards. Awareness. For safeguarding the well-being and interests of consumers through education, mobilization, and representation. The government, in collaboration with NGOs, should publish periodicals to impart knowledge about consumer problems, legal reporting and redressal measures, and organize awareness campaigns. E.g. Jago Grahak Jago. Roles and responsibilities. CCPA's roles concerning investigations and inquiries and search and seizure operations should be clearly outlined in matters such as product recalls, appeals, etc. Enlisting duties. Regulation sections can explicitly mention consumer duties to guide to ensure a responsible consumption ecosystem. For example, the Jamaican government recognizes both rights and duties of the consumer and publishes these on their official website. 1.7 Scheduled Tribes and Other Traditional Forest Dwellers, Recognition of Forest Rights, Act, 2006. Why in the news? Recently it has been reported that the states have rejected nearly 40% of the land claims under Forest Right Act. About Forest Right Act, FIA, 2006. Before the enactment of this act, earlier acts did not recognize the symbiotic relationship of the SDS with the forests and their dependence on the forest. Section 3, 1A, of the FIA recognizes the right of the forest-dwelling tribal communities, FDSDs, and other traditional forest dwellers, OTFDs, to hold and live in the forest land for habitation or for self-cultivation for livelihood. Types of rights under Section 3 of FIA Act. Individual forest rights, IFR right to hold and live in the forest land under the individual or common occupation for habitation or for self-cultivation for livelihood. Community forest rights, CFR seeks to restore all customary and traditional usufruct rights of forest-dwelling communities. 17 WWW. It will be within the traditional or customary boundaries of the village, irrespective of the ownership, classification, and size of forests. Community forest resource management rights, right of ownership, access to collect, use, and dispose of minor forest produce, which has been traditionally collected within or outside village boundaries. Nodal agency, as per Act, the responsibility for implementation of the Act lies with state governments, EUT administrations. Role of Gram Sabha. The Gram Sabha is the authority to initiate the process for determining the nature and extent of individual or community forest rights, or both. Land titles. Act recognizes the rights of an individual or family or community on the land, however claim should not exceed more than 4 hectares. Land title given under the FIA is a legal title. Land rights conferred by the Act were heritable, Section 4(4) of FIA, but not transferable or alienable. Diversion of forest land for local development rights, establishment of schools, dispensaries, or hospitals, Anganwada centers, etc. 3-tier approval process. Gram Sabha is the primary authority for initiating the whole process by receiving and verifying the claims. Aggrieved person from the resolution of the Gram Sabha may file a petition to the subdivision level committee, SDLC. Any person aggrieved by the decision of the SDLC may file a petition to the district level committee, DLC. Decision of the DLC on the record of forest rights shall be final and binding. Scheduled areas. In Act means the scheduled areas referred to in Article 244 of the Constitution. Protected areas. FIA is applicable in national parks, wildlife sanctuaries, and tiger reserves. Concerns related to the Act. Land claims related. Document of proof. Many IFR claims were rejected because applicants did not provide adequate documentary evidence of this use of the land. For e.g., according to Section 2(c) of FIA, to qualify as FDST, Small Black Square must be a scheduled tribe in the area where the right is claimed, and Small Black Square primarily resided in forest or forest land prior to the 13th of December, 2005, and Small Black Square depend on the forest or forest land for bona fide livelihood needs. Inconsistency in acreage claimed and acreage allocated. 4E.g as per World Bank report, in Nimrata district of Gujarat, around 70% claimants reported that the IFR claim was approved for lesser acreage. Low awareness. The Gram Sabha, which initiates the verification of FDSDs, OTFDs claims, are low on awareness about how to deal with them. An analysis of FIA implementation in Jammu and Kashmir between September 2021 and May 2023 highlighted that more than 92.57% of the rejected claims have been declined by Gram Sabha only. Also, the locals being illiterate and living in remote areas, FDSDs, OTFDs, do not know the appropriate procedure for filing claims. Other concerns with the Act. Forest land encroachment, misuse of Gram Sabha for approval for ineligible claimants, and regularizing encroachments made after the 13th of December, 2005, cutoff date of recognition. When the applications get rejected, applicants file an appeal and the case drags on for years and remains encroached. Violation of FIA provisions. Earlier titles were randomly issued in the name of JFM committees or Panchayat bodies. 18 www. For example, CFR titles were issued to 10 villages in Deora Taluk of Gondia district of Maharashtra showed that the DLC had issued titles in the name of the Panchayat instead of the Gram Sabha. Lack of coordination. As per the Act, SLC, DLC, and the state level monitoring committee shall consist of officers of the Departments of Revenue, Forest and Tribal Affairs of the state government. However, they lack coordination to fulfill the objectives of the Act. Destruction of forests and wildlife. Environmental conservationists raised concern that FIA Act, due to its land rights and minor forest produce use, might affect the biodiversity of the forest. In several cases, trees on the forest land are chopped and claims are made under the FIA. Way forward. Issuing directives to states. Under the FIA Act, the Centre can issue directives to states to ensure a review exercise in line with the law in case of such a high rejection rate of claims. Learning from state government. Odisha government's Mo Jungle Jami Yojana, MJJY, implementation of the scheme will provide ownership of land and access to forest resources to the beneficiaries. Awareness generation. Awareness generation among Gram Sabhas, forest rights committees, FRCs, and IFR, CFR claimants about FIA and its rules and regulations need to be improved. Capacity building of Gram Sabha. As Gram Sabha is the primary authority of approval, there is a need to improve capacity through training and effective use of local bureaucracy. Others, involving marginal sections like women, increasing role of civil society, etc. 1.8 News in Shorts. 1.8.1 Unlawful association, under UAPA, 1967. Ministry of Home Affairs declared the Jammu and Kashmir Democratic Freedom Party as an unlawful association under the Unlawful Activities Prevention Act UAPA, 1967. UAPA was enacted for effective prevention of certain unlawful activities of individuals and associations, for dealing with terrorist activities, and for matters connected therewith. Key provisions: offences are cognizable, arrest could be made without a warrant. O penalty, death or imprisonment for life, and shall also be liable to a fine if such act has resulted in the death of any person. O unlawful association declaration of an association unlawful by the Centre through an official gazette notification by specifying the grounds. Reference to tribunal. On the declaration of being unlawful, the notification should be referred to tribunal within 30 days. Small black square tribunal consists of one person, a judge of a high court. Other powers to Centre small black square, to prohibit the use of funds of an unlawful association small black square, to notify places used for the purpose of an unlawful association. O Terrorist Act, definition. It includes any act intended to threaten the unity, integrity, security, or sovereignty of India or strike terror people in India or in any foreign country among others. Forfeiture of proceeds of terrorism by the investigating officer with the prior approval of the designated authority. 1.8.2 Online registration of first information reports, FIR. 282nd report titled Amendment in Section 154 of the Code of Criminal Procedure, 1973 for enabling online registration of FIR, submitted by 22nd Law Commission to the Ministry of Law and Justice. 19 www.vision. O Section 154 of the Code of Criminal Procedure, 1973 governs how the first information about the commission of a cognizable offence is recorded. Recommendations. O EFIR be enabled in a phased manner. Registration of EFIR is to be permitted for all cognizable offences, where the accused is not known, or attracting punishment up to 3 years, where the accused is known. O states have the power to expand the list of offences. O privacy of the parties to be ensured. O verification of informant, a complainant, and punishment for false information. O e-complaint to be allowed for all non-cognizable offences. Complaint means any allegation made orally or in writing to a magistrate, with a view to his taking action under this code. O capacity building to be given importance. Significance. O citizens can report crimes conveniently and efficiently. O complainants can also check the timely status of their complaints online. O it helped in reducing the footfall at the police station. 1.8.3 Centre claims Aadhaar as the most trusted digital ID in the world. Refuting the claims made by an investor servicing agency, the Centre has claimed that Aadhaar is foolproof. Aadhaar is a 12-digit individual identification number issued by Unique Identification Authority of India, UIDAI. O the collected data is secured in the Central Identities Data Repository, CIDR, of UIDAI. Key features of Aadhaar. O uniqueness. The biometric deduplication avoids multiple cards issue for same information. O random number. The generated number is random and devoid of any details like caste, religion, income, etc. O architecture is open and scalable. The current authentication service can handle 100 million authentications a day. Measures taken to ensure safety of Aadhaar. O UIDAI has introduced a two-layered security mechanism for Aadhaar-based fingerprint authentication to secure Aadhaar. O Parliament has laid down robust privacy protections in the law governing the Aadhaar system through robust arrangements. Section 32(3) of the Aadhaar Act 2016 prohibits UIDAI from controlling, collecting or maintaining any information about the purpose of any authentication. O the authentication systems are certified as per international security and privacy standards. ISO 27001:2013 for Information Security Management System and ISO 27701:2019 for Privacy Information Management System. 1.8.4 Cable Television Networks Regulation Act 1995. The Ministry of Information and Broadcasting has notified amendments in the Cable Television Networks Rules, 1994. O it provides the operational mechanism for implementation of the decriminalized provisions of the Cable Television Networks Regulation Act 1995. Aim, to make the Cable Television Networks Regulation Act of 1995 more business-friendly and to boost investor confidence and ease of doing business. 20 WW. Sections of the Act were re-examined and were decriminalized through the Jan Vishwas Amendment of Provision Act 2023. The imprisonment provisions have been now replaced with monetary penalties and other non-monetary measures like advisory, warning, etc. 1.8.5 Sana Code. Jharkhand government is seeking recognition of Sana religious code for tribals. Sana followers are nature worshippers who do not consider themselves Hindus and have been fighting for a separate religious identity for decades. O so far, the census surveys have included them as others in the religion column. O believers of Sana faith do not practice idol worship, nor do they adhere to the concept of the Varna system, heaven, hell, etc. O holy grail of Sana faith is Jal, water, jungle, forest, Zameen, land, and its followers pray to trees and hills. 21 www.visioneer